This is a lecture from my professional responsibility course about Model Rule 3.3, which is Candor to the Tribunal. Some of our rules in the ones that start with 3, they all relate to litigation, and some of them, like 3.2, are very short and simple and don't need a lot of discussion. 3.3 is one of our more complicated ones that has some parts, and we're actually going to have to do 2 video lectures, break it up so it doesn't get too long to talk about this one. So this one we're going to go through the rule and the first few comments, and in a part 2 lecture, I'm going to go through the remaining comments because the comments are really extensive for Model Rule 3.3. So 3.3a, a lawyer shall not knowingly, 1, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2, fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. So here we're talking about candor to the tribunal, which, and if that's an unfamiliar term for you, we mean truthfulness. Rule 3.3, you could think of it as one of our anti-lying rules. So we're going to have some rules in the model rules that actually require disclosure. We're going to or require truthfulness, and then we're going to have some other rules that actually require keeping client information confidential, and so we have a core confidentiality rule, and then a cluster of other rules that implicate confidentiality duties. This is one of our duties, to be truthful or make statements, even when it's to the disadvantage of your client. And so keep that in mind, that this rule can be in tension sometimes with a duty of confidentiality. So when we talk about making a false statement of fact, you are simply not allowed to straight up lie to a judge. You are not allowed to lie to the judge, like right to the judge's face about something. And this could be about facts or law. So if the judge asks you, does your client have any prior convictions? And your client does, and you say, no, Your Honor, you just lied, right? And you're not allowed to do that. And for some of you, and especially for non-lawyers, it could be surprising that we have a rule against lawyers lying. That there's sometimes when lawyers are not allowed to lie, but you're not allowed to lie to the judge in court. And the same is true about the law, right? If the judge says, is there a statute that governs this? And there is, and you say, no, Your Honor, you just lied, right? So you don't get to, if you're asked a question point blank, you have to answer truthfully. And in fact, if you make a false statement, whether nervously, you're kind of one of these people who lies nervously when you're stuck and you feel bad about it afterwards, or even inadvertently, you just misspoke, right? And in the situation, and as soon as you walked out of the court that day, you realize, wow, I actually said something that's not true. You have to go back and correct it. If there's an opportunity to go right back in the courtroom and do it, the judge is still there, great. If or before you leave the courtroom, or the next time you have a hearing, you have to correct it. You actually have an affirmative duty to undo a false statement that that you made to the judge. So that's part 1. Part 2, I hope that you heard about in your legal writing class or something like that early in law school. And this is about when you're doing legal research. And so here's our scenario. Someday you're doing legal research, and the other side has filed a motion, let's say a pretrial motion and a brief, and you are researching a counter motion, a reply motion in your brief, let's say, and you come across a case, and it's a nightmare case for you. I mean, you don't understand why the other side didn't cite it in their brief, because it's fatal to your side. Right? And it's right on point, and it's from your jurisdiction, and it's binding precedent, and it basically says that you lose, or that your client loses this case. Well, maybe you're tempted to think, woohoo, the other side didn't find this, and so let's hope that no one ever does. I'm not telling anyone. But actually, you have the duty, and this could be a painful duty, to to come forward with it. And if it's controlling precedent. Now, if it's just persuasive authority from another jurisdiction, you don't, right? You don't have an ethical duty to bring forward unfavorable persuasive authority, but binding authority in your jurisdiction that goes against you, if the other side hasn't, then you have to bring it up. Now, if the other side has brought it up, you don't have to bring it up. It's already before the tribunal. But you are going to have to disclose it. Go ahead and try to explain it away. Say, well, the facts were different, or something, or it's time for a change, or whatever you want to do to try to explain it away. But we don't want to embarrass the tribunal with an unnecessary reversal, and also we're wasting everybody's time, because if there's already controlling precedent, that this is going to get appealed, and at some point the appellate court is going to figure it out and is going to report it. Okay, so that's part two. Also, please note this doesn't just apply to cases, it also applies to statutes or regulations or anything that could be controlling law, legal authority in your jurisdiction. And so again, we spend a lot of time first year teaching students to do case research, and some students honestly are a little weak on statutory research, and it doesn't occur to them to see if your state happens to have a statute that's on point, and if there is, and you find one, you have to disclose that too. Why? Because the courts are bound by the statutes. Okay, 3.3a. You shall not knowingly offer any evidence that you know to be false. And it goes on. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer must refuse to offer evidence other than the testimony of a defendant in a criminal matter, because that person has a constitutional right, that the lawyer reasonably believes is false. And so notice that reasonably believes is a little different from what we have in the lead sentence, which is if you know something is false, you can't offer it as evidence. And so it's not just that you're not allowed to lie to the judge. If the client gives you, I don't know, documentary evidence, business records or something like that, and then tells you, by the way, I falsified these, or I filled out these forms with false information, you can't submit them as evidence in court. It's an ethical violation. And so, nor can you make a deep fake video or forge a document on behalf of your client or something like that. So even though you're not orally lying to the judge, you're also not allowed to fabricate evidence or submit evidence that you know was fabricated and that is false. And if you do this or your client does this, let's say your client gets on the stand and lies and lies and lies, or you call a witness and they lie and lie and lie, you have to take remedial measures. Now, when it says if necessary disclosure to the tribunal, I mean, the best way is to do something like recross or ask another question to try to give them an opportunity to undo the lie themselves. So if you're doing direct examination at trial and your client or the witness it's your witness has just that they lied, you could ask them if they would like to rephrase their statement or correct a misstatement or something like that, and give them an opportunity to clear it up. Otherwise, you're going to have a duty to rat on them and to tell the judge. Or you can ask for a recess or a moment to talk to your client and try to talk some sense into them or the witness to admitting that they said something that's not true, and have them backtrack from it. That's probably the best recourse. If they refuse, then you're going to have to do that. Also, now notice that it's an absolute prohibition on submitting evidence. You're also permitted to refuse to offer evidence that you reasonably believe is false. Not required, right? And notice the technical difference. You don't know it's untrue, but you don't believe it. And so, I mean, in theory, it could be true, but you think that it's a lie or something like that. Then you won't be subject to discipline if you say, I'm sorry, I'm not going to call that witness. Just tell the client, no, I'm not going to file this, and because I don't believe you. So that is okay. B, this is 3.3b. A lawyer who represents a client in an adjudicative proceeding and who knows that a person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct related to the proceeding shall take reasonable measures, including, if necessary, disclosure to the tribunal. What are we talking about? Witness tampering, threatening or bribing witnesses, threatening or bribing jurors, things like that. Something that's criminal or fraudulent that's related to the trial. You're trying to rig the trial. You're not allowed to, if you know that your client is doing that, you actually either have to try to get them to stop and undo the damage, or you're going to have to tell the judge on them. C, the duties in paragraph A and B continue to the conclusion of the proceeding and apply even if compliance requires disclosure of information otherwise protected by Rule 1.6. Two important points for test purposes from C. Number one, this could be a gotcha question on the MPRE. The duty to clear up, to tell on your client, let's say, for lying, or to clarify something you said that you now realize was untrue, only proceeds until it continues until the end of the proceeding. And so once we have a verdict, actually you don't have to go in and correct it if you find out about its falsity after the fact. So if your client, while you're waiting for the verdict, tells you during a recess, by the way, I just lied on the stand, or by the way, I know that you told the judge this, but that I actually lied to you, and that the truth is I have 16 convictions or something like that, you have to walk right back into that courtroom and say, Your Honor, I need a moment. I misspoke, or I was misinformed, and here's the real story. On the other hand, if the trial is done, then the day after the trial, the client calls you and says, hey, by the way, I did this, or I lied on the stand, or I lied to you, you don't have to fix it. So please, that's a nice binary either or thing that's easy to turn into multiple choice questions. Secondly, and this is very important for the MPRE, I think the hardest questions on the MPRE are the ones where they give you a hypothetical that's in tension between one of our truth-telling or required disclosure rules and the duty of confidentiality to keep the client secrets under 1.6. Pay very close attention when you're studying for the MPRE to all the places where the rules or the comments tell you which rule wins when they're in tension. And here, 3.3 wins over 1.6. There will be other cases where 1.6 wins. Pay attention, 3.3 wins if it's a contest between it and 1.6. D, very quickly, in an ex parte proceeding, the lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse. What are we talking about? There's some proceedings in our legal system where there's not another lawyer present, and you have a heightened duty to present both sides. And I want to clarify that the implication of this is that most of the time you don't, right? And so if the other side, let's say there's some facts that are really damaging for your side, and the other side is kind of incompetent or dropping the ball and not bringing that up, you don't have to volunteer unfavorable facts or inconvenient truths. That's not on you. It's a little different if you're the only lawyer there with the judge in an ex parte proceeding, and by far the most common type of ex parte proceeding are pretrial restraining orders or TROs or things like that, or injunctions, pretrial injunctions, where one party goes in and says, I need a restraining order. And this could be a restraining order like, I need this person to stay away from me, like the cop show type restraining orders. Or it could be a pretrial restraining injunctive relief, like, I want this lawyer to have to turn over records now, or have to stop using the same name as this or something. And basically, you're asking for pretrial equitable relief. And now what's going to happen is the judge can grant that to you, and then the other side will have an opportunity to schedule a hearing and come in and ask for the stay or the injunctive relief or the TRO to be lifted. And But while you're there, you have a heightened duty to present facts so that the tribunal can make a fair and informed decision, and not to slant things. You can go ahead and advocate and present all the arguments for your side, but you're not allowed to hide some crucial facts that, of course, the judge would want to have known. Okay, comment 1. This applies when the lawyer is representing a client in ancillary proceedings, like deposition. So keep in mind 3.3, the duty of truthfulness and the duty to keep your client from lying apply in depositions and things like that, not just the courtroom. Comment 4, I'm skipping some of the comments that I think are unnecessary to spend time on that merely restate the rule. Legal argument based on knowingly false representation of law constitutes dishonesty towards the tribunal. A lawyer is not required to make a disinterested exposition of the law, but must recognize the existence of pertinent legal authorities. In other words, you don't have to argue that it's for the other side, like why a case should apply to you or something like that, and make legal arguments for the other side. But you can't hide a binding case or a binding statute. And so you can go ahead and address it. And when you're talking about that legal authority and any others, go ahead and be an advocate. Say the unfavorable ones shouldn't be given as much weight as the ones that support us and stuff like that. That's fine. And the judges know to watch for that. You have a duty to disclose directly adverse authority in the controlling jurisdiction, as we've said. Now, paragraph A3 requires the lawyer refuse to offer evidence the lawyer knows to be false, regardless of the client's wishes. And keep in mind, if you get a question where the client says, I'm the client, you're my lawyer, you have to do what I say, and I want you to submit these fraudulent tax returns or these business records or forms that I filled out fraudulently, if you know they're false, it doesn't matter that what your client wants, you have to refuse to submit them. And if the client says, I really want you to have my best friend testify because he's going to corroborate my alibi, and of course and then you watch them rehearsing it and concocting a fake alibi or fake story right in front of you, it doesn't matter what your client wants, you have to refuse. On the other hand, this kind of goes without saying. If let's say you're the lawyer for the government and you're charging someone with tax fraud, you can submit a copy of their fraudulent tax returns, and that's not a violation, obviously. You're submitting it to establish its falsity. And so just in case you were thinking technically, I can't submit a falsified document even when I'm trying to show that the other person falsified the document. Of course you can. Skipping to comment 6. If a lawyer knows that the client intends to testify falsely or wants the lawyer to introduce false evidence, the lawyer should seek to persuade the client that the evidence is not to be offered. If the persuasion is ineffective and the lawyer continues to represent the client, the lawyer must refuse to offer the false evidence. And if the MPRE gives you this as an option, the right answer is try to talk sense into your client. That's supposed to be your first recourse. And then your last recourse is to refuse, or if the client has already offered it, to tell the judge and so forth. So the model rules right here say you don't have to withdraw just because your client says, hey, I want to have my friend lie on the stand and get me off. You have to say you can't do that, that's perjury and stuff like that. And sometimes non-lawyers, they will back down and say, oh, I didn't know. And so that's what we want you to do. If only a portion of a witness's testimony will be false, you can still call the witness and just avoid that subject, right? And they may be very frustrated. They're wanting you to get to the good part where they have this great lie that they've planned on telling. And you can put them on the stand, get the testimony that you want, and then sit down and let the other side do cross-examination. And that's going to conclude this part of our discussion about Model Rule 3.3. There's a follow-up video where we're going to go through the remainder of the comments because the comments are so extensive.